What is the historical evolution of the insanity defense? Imagine a time when the law didn't really consider mental health at all. For centuries, the idea was simple. If you committed a crime, you were responsible. But as understanding of the mind grew, so did the way courts approached mental illness in criminal cases. The insanity defense has a long history that shows how society's views on responsibility and mental health have changed over time. In ancient civilizations like the Hebrews, Greeks, and Romans, the concept of excusing the insane from blame was already taking shape. Hebrew scriptures from the 6th century BC grouped children and the mentally ill together, saying they couldn't be held responsible because they lacked the ability to form criminal intent. Romans, under the Code of Justinian, also recognized that the insane should not be punished for their acts. These early ideas focused on whether a person had the mental capacity or intent to commit a crime. During the Middle Ages, legal thinkers like Henry Broughton in the 13th century built on these ideas. They argued that the insane, like children, could not from the necessary mental state called mens rea, or guilty mind. Early English law started to requiring proof that a person was unable to understand what they were doing or the nature of their actions. The biggest shift came in the year 1843 with the case of Daniel Monodon. He suffered from delusions and believed he was under threat, which led him to kill the British Prime Minister's secretary. He was found not guilty by reason of insanity. This case prompted the House of Lords to create the Monodon Rule. This rule set a standard. A person could be considered legally insane if they had a severe mental disorder that made them unable to understand what they were doing or that it was wrong. This became the foundation for many legal systems in the years that followed. Later on, courts began to recognize that mental illness might impair not just understanding but also control over actions. This led to tests like the irresistible impulse test, which asked if a person could control their behavior despite knowing right from wrong. The Durham test, introduced in the 20th century, focused on whether the crime was a result of mental disease or defect. However, it was criticized for being too lenient and hard to apply consistently. In the 1960s, the American Law Institute created a new test that combined both understanding and control. It said a defendant lacked substantial capacity either to appreciate the criminality of their conduct or to conform their behavior to the law. But in the 1980s, public concern about abuse of the insanity defense led to reforms. The federal government adopted a narrower standard that emphasized cognitive incapacity, making it harder to use the defense successfully. Some places even introduced a verdict called guilty but mentally ill, which allows for conviction but also recognizes mental health issues. Today, the insanity defense remains a complex part of criminal law. It's used to argue that mental illness prevented a person from understanding or controlling their actions at the time of the crime. Proving it involves careful psychiatric evaluation and legal arguments based on specific standards. While not easy to win, it can lead to treatment instead of punishment. Over the centuries, the evolution of the insanity defense reflects society's ongoing effort to balance justice, responsibility, and compassion for those with mental health challenges.